come
Yes.
back to the petitioners?
Yes.
Then
Your Lordship, thank you for your great patience. That goes to show that this is a matter, as I started by saying, of grave national importance. And I'd like to note 14 million subscribers to M-Pesa. We didn't lay a claim that we're here to represent them, but they're all interested. You see, there's a famous doctrine in law, res ipso locuta. Facts speak for themselves. It's a matter of grave national interest to all the Kenyans. My Lord, it has been argued by my learned friends that the court should respect the doctrine of separation of powers. Yes, there was no problem with that. But Parliament, in its wisdom, or lack of it, went against a court decision, which was issued by your learned brother on the 23rd of March. They went ahead, on the 31st, you had it so eloquently placed before you. So that is a kind of respect for separation of powers that our Parliament has. Your Lordships, it's the same Parliament. I've been a member of Parliament for quite a while. Yes, and Articles 1 and 2, that the sovereign power, the separation of the people of this country rests in the people, which can be exercised either directly or indirectly through their elected representatives. And where the elected representatives falter, as they did with the finance bill in 2024, then the citizens have a right to exercise it directly. Your Lordships, that's what the Gen Zs did. It is the same Parliament, Your Lordships, that went against a direct court ruling. Just an example, that our policemen were not to be deployed to Haiti. We thank God they've all come back -3 or 4. Against an express order of the court, this Parliament and the executive.
May I respectfully point out
Which
that
is
the
an
reply is
example,
limited
John.
to matters of law.
This is a matter of law, my Lord. It's really a matter of law.
It is not a matter
This
of
is decisions of the courts, my Lord, that have been.
he's trying to demonstrate
I think you're
a
to
kind
respect that.
of respect that should be
I'll
there.
be very brief for your
Within the
comfort.
separation of powers. So I'll allow you to give that one example only.
Yes.
Don't give it the other.
Okay.
Let him exercise politics.
And let me then.
After that, let him revert back to being a lawyer.
Oh my, that is what I am, my Lord. I'm here in that capacity.
You are the good people.
Because we're just trying to highlight how the executive
Yes.
and Parliament have failed to respect court decisions. And they do so with impunity, including the security laws, which were ruled unconstitutional. So, my Lord and my ladies, the orders by Justice Mugambi are very clear. It is ordered under paragraph 2 that the balance of justice in favor of granting immediately an order that the status quo to be maintained until the bench, which is this bench, is in place. I think we are in agreement that the onus is on your Lordships to extend these orders, and that is our plea very strongly. My learned sister Abdallah is scared that I was going to produce a CR 12 to prove the point, my Lord and my ladies, that Vodacom South Africa. Vodafone, Netherlands, own 350 shares out of a total of 400 shares in Safaricom. Is it Safaricom Kenya Limited? Yeah, Vodafone Kenya Limited. Vodacom Kenya Limited. 50 shares by the Netherlands Vodafone Group and 350 shares by Vodafone South Africa. Therefore, Vodacom Kenya Limited, your lordships, is a completely foreign-owned company. That is the truth of the matter. That is truly the matter. To allay the fears of the chairman of CPK, I wish these very reputable international organizations will stand guided by the fact that there is a contestation about the share of these shares. I personally, on behalf of the Kenyan people, because they can get a better deal, that's for sure. In business, you don't get what you negotiate, you don't get what you deserve, you get what you negotiate. It's a negotiation issue.
Matters of law, my lord, matters of law.
So to say,
law.
no, I'm just responding to what your able chairman of CPK said.
Wait, John,
Yes.
that was an issue which was raised.
It was raised by, yes, from the bar. Yeah, from the bar. And I have the right to respond. Because, my lord, it was expressly raised. So it must be contradicted. Because all this in an effort to make believe there is not an issue of an urgent national importance before your lordships. This is why we seek these conservatory orders. Well, even the very fact of National Infrastructure Fund, maybe for information of CPK Chair, CS Buddy is before the IMF board, just for information. And these are the issues that they are confronted with. And some of this infrastructure fund itself is subject to litigation. So my lord and my ladies, nothing, we have shown, we have proved that Parliament acted in bad faith, which is one reason why, because they went against the ruling of Justice Mugambi. My friend Muganda wanted to show one thing that goes to show this need to issue conservatory orders. Because if we don't, your lordships, we will come here and be engaged in some academic exercise when everything will have happened. We are all Kenyans. We love our country. And believe you me, we will prove, and I don't want to argue that point, because it is in our main petition, the undervaluation of the Safaricom shares. We will not allow this, your lordships, just to go unnoticed. Therefore, I strongly urge that when you retire, to consider your ruling, you'll act in a manner, as we all know you well, justly, and taking into account public interest, the immense public interest. Even taking 40 billion upfront, you want to forego your own profits? What are you telling the country? My friends may want to add one or two things.
Yes, my lord, thank you very much. I have sat down here seeing my learned senior, Mr. John Ohaga, tell you that orders of Justice Mpochi were ousted or were stayed by the court. That is not true. The truth of the fact is that application E14 of 2026 was heard before Justice John Mativo, Justice Gashoka, and Murungi. And they said that they cannot stay declaratory orders or orders of certiorari, as has been held in so many decisions of the Court of Appeal. So all the submissions, all the interactions made by Mr. John Ohaga should be expunged because he's representing an Attorney General contrary to orders of Justice Mohochi, which were not ousted.
What is the case number?
The case number is E014 of 2026. It's the application that was before the Court of Appeal. And if you look at the conclusion of that particular ruling by the three judges, it is clear that they declined to stay the order, declaratory orders because they are negative in nature. That is very clear.
When was that?
It was done on the 10th day of March 2026. My Lord, on joinder, we have been told that Irongo Nyakera and the governor, former governor of Nairobi, have no interest. My Lord, you cannot trash Article 22 on local standard. And secondly, Irongo Nyakera, for example, is the one who negotiated the IPO in 2007. And therefore, this is someone with a lot of, actually, Mr. Andrew Mukita Musangi comes second to the information that he has about Safaricom, to Mr. Nyakera, to the intended interested party. So therefore, my Lord, these are not idlers. They are not mischief makers. They are people with substantive information that can assist this court arrive at a just and conclusive determination. The Lord, my learned colleague, whom we learn a lot from, Senior Kalonzo Musyoka, Ambassador, has told you that Parliament violated the doctrine of separation of powers. My Lord, if you look at Standing Order number 89, it bars Parliament from proceeding on matters that are pending in court, so that it is sub judice. And the Attorney General is well represented in this matter and ought to have informed the speakers of National Assembly. Information which we believe that the speakers would have ignored, that this matter is pending in court. Standing Order number, and I think Article 103 of the Constitution of Kenya is very clear that standing orders, my Lord, are part of this Constitution. I think 103. Someone check for me.
Standing order number
89.
Standing Order 89 of the National Assembly, not of the Senate. Standing Order.
No, it's actually Standing Order number 89 3C.
Yes,
It's what I was about to address you on, but you told me to hold my process.
Yes, my Lord, Harrison Kenyanji ought to have been my pupil master. But for some reasons I never went to his chambers. Thank you very much, Senior. That is the Standing Order. It's very clear that the committee of the three arms of the government does not allow Mr. Masika Wetangula or Amason Jaffa King, the Speaker of the Senate and the National Assembly respectively, to admit matters that are pending before this court. And I'm reminded by my learned senior, your team, that both are lawyers, actually senior counsels, I'm told, and therefore they ought to have known that this matter is pending before Parliament, before this court, and it would be prejudicial for them to continue to deliberate on them. My Lord, my Lord,
your permission. My good friend and brother, who I believe should be in Parliament because he has a lot of compassion, knew the significance of this matter. For some reason, there was a deliberate omission of both the National Assembly and the Senate in being enjoying these proceedings. So they are accusing a party that is not present before this court for response.
On that point, I think you have said enough.
yes, my Lord, I have said enough.
Also buttressed by...
Yes, before I was actually stood
Now
down.
we go to the next point.
The next point is on the affidavit of Mr. John Bandingongo, the CS, Treasury, which my learned colleagues glowingly talk about. My Lord, if you look at that particular affidavit, it fails to annex the Hansard of that particular day, because even members like John Karoli Omondi, then people opposed and actually brought to the attention of the Speaker that whatever they were doing is not in the best interest of Kenyans. My Lord, then people Suba.
Yeah, and he's a lawyer.
And he's also a lawyer, my Lord, I'm told.
No, he is.
Yes, an advocate of the High Court of Kenya. My Lord, I wish to bring your attention to our further affidavit, dated the 15th day of April 2026, in reply to John Bandingo's further affidavit. We have annexed that particular Hansard. We have also annexed a 15-page memorandum dated the 26th day of January 2026 by the Law Society of Kenya. Law Society of Kenya was advising Parliament under Section 4, I think, of the Law Society Act. And my Lord, they are very clear, and my learned colleague alluded to this, my learned senior, that even though they recognize the importance of having a free debt country, you do not sell the goose that lays golden eggs. That's the conclusion of the 15-page, the conclusion of that particular memorandum, 15-page, that is annexed to the affidavit of Mr. Ashoka, Tony, and his learned petitioner, his good petitioner, Professor Ogola. So therefore, it is not idle when we say that Parliament, National Assembly, is not acting in the best interest of, and that is well canvassed in that particular replying affidavit, which was filed yesterday, and annexures were done. What Mr. Marwa's client, and because I don't want to call him John Ogata.
I don't want you to go into details because you are exercising your right of reply.
Yes, I'm only trying, my Lord, with due respect, to debunk what that particular affidavit, which they have referred almost 10 times, by Mr. Ohaga, who is not even supposed to, because he does not represent, he is not supposed to represent the Attorney General, and Mr. Marwa. That particular affidavit has been responded to effectively by Mr. Ashoka, and you can see the mischief of Mr. John Badingongo of material non-disclosure. So therefore, my Lord, the conservatory orders that we have sought, we urge this court, if you are consider our submissions that are dated the 29th day of January 2029, that were also read by Justice Mugambi before he issued conservatory, or they don't want me to call them conservatory orders.
They're not.
Yeah.
Before
Let's avoid calling them
status quo orders. And my Lord, I believe before this court rests to write its decision, we'll read the notes that were taken by Justice Mugambi, and all whatever they have said here was recorded, and those status quo orders were issued. And therefore, my ladies, my Lord, you have been told not to give a preemptive strike by the Central Bank chairman, board of directors. My Lord, what that amounts to is that you are being told, don't issue that, so that we go and score on the other side, so that you come here, 3 judges of probably about around 70 years of experience from the time they were admitted to the bar, to engage in an academic exercise. My Lord, tunaomba tafadhali. And I started by saying Safaricom PLC is as important to Kenyans as the Strait of Hormuz are important to the people of the Republic of Iran. Unless there is a question that you want me to clarify, I call upon Mr. Ndegwa to cross-pollinate on what I've said.
Yes, Your Lordship, I'll be very brief. Your Lordship, may I disabuse the notion that we are not making an application for conservatory order. I refer you to the case Nairobi Civil Appeal 151, which is Invesco Insurance Company Limited.
So you know you have an application for conservatory orders.
Yeah, I'm coming there. I'll show you how I'll link and annex this status quo to that order.
I would like
By
you to
this
keep
court.
them separate.
Yes, Your
The
Honor.
status quo and the other.
May I just read this judgment?
Yes, continue.
Civil Appeal 151.
An authority,
Yes, I'm reading.
we have to have the right to
They are
comment on
opening,
it. He had the opportunity,
But
my
he's-
lord,
they are asked
to refer to
reply,
authority.
and they never end.
Your
This
Lordship,
is never going to end, my lord. As long as you keep that door open.
My lord, we concede.
You also heard me.
We concede and we
I wanted to say, from the process power,
to respond on points of law.
1948, KB 408 explicates the status quo. Has been used repeatedly. What is the status quo ante? What is the status quo post?
Yes.
That I would have said.
So, just